Next, we'll break down some important key terms from Article 2, including buyer, seller, merchant, and good faith. Article 2's definitions of buyer and seller are fairly straightforward. A buyer purchases goods or contracts to buy them, while a seller sells goods or contracts to sell them. For example, if a farmer contracts with a livestock dealer to purchase 10 cows for $12,000, the farmer is the buyer and the dealer is the seller. Of course, things can get a bit more complicated when more actors are involved. Let's say the farmer sends a farmhand to purchase the cows. As long as the dealer knows that the farmhand is acting as the farmer's agent, the farmer is still the buyer, not the farmhand. Similarly, if the farmer negotiates and contracts with one of the dealer's agents, the dealer remains the seller. However, in both cases, if the principal's identity isn't disclosed, the agent may be deemed the buyer or seller. Further, if a middleman was involved in the sale, the middleman would be the buyer as to the dealer, but would be the seller as to the farmer. Article 2 has several specialized rules that only apply to merchants. Thus, it's important to understand the term. Article 2 recognizes two types of merchants: merchants concerning the practices involved in the transaction, and merchants with respect to goods of the kind involved in the transaction. Although many of Article 2's rules apply to merchants generally, some rules apply only to merchants with respect to goods of the kind. A merchant concerning the practices involved in the transaction is someone who, by their occupation, holds themselves out as having knowledge or skill peculiar to the practices involved in the transaction. Almost any professional business person acting in a business capacity could fall under this category.